Assalamualaikum warahmatullahi wabarakatuh. My name is Andina Uliana Azahra. My metric number is 260906.
Hello, my name is Naura Kisti Atifah, 261204.
My name is Salwa Ali Sadani, metric number 260388.
Right now, I want to tell about the use of force in self-defense. States may legitimately resort to the use of armed force in self-defense, according to the UN Charter, Article 51. But what is the meaning of the self-defense? Self-defense is a lawful reaction to the armed attack against the territorial integrity of a state, which also diminish its political independence. By executing the right to use of force in self-defense, states are conducting a unilateral act. The traditional meaning of the right to use force in self-defense was adopted by the Caroline case, which happened in 1837. These principles were accepted by the British government at the time and form a part of customary international law. This Caroline case set out a customary international law definition of the right to self-defense. It originates from a dispute between British government and the U.S. Secretary of State regarding the destruction of an American vessel in American port by the British subjects. The reason behind this act was the use of vessel to transport the ammunition and group of Americans who were conducting attacks on the Canadian territory. The U.S. government declared that the attack on the vessel constituted an attack against the American territory. The British government responded by claiming the right to use of force in self-defense. The subsequent diplomatic correspondence between the parties contained an outline of the key elements for legitimate self-defense. The U.S. Secretary of State, Daniel Webster, emphasized that for the self-defense to be lawful in international, the British government must prove the necessity of the use of the self-defense, instant, overwhelming, leaving no choice of means and no moment for deliberation, and that assuming of such a necessity existed at this time, the act justified by the necessity of self-defense must be limited by that necessity and kept clearly within it. Thank you.
In the second part, I will talk about the law of armed conflict. International humanitarian law acts as less specialist or law governing a specific subject in international law. It sets out rules applicable to a very specific situation in international relation, the state of armed conflict. The main aim of IHL is to limit the detrimental effect of warfare by providing protection to those who do not take part or no longer take an active part in the hostilities. It also defines rules of conduct for those who engage in armed conflict and provide restrictions regarding the method and means of warfare that can be employed. Traditionally, the law of armed conflict is divided into two branches. The first one is the law of Geneva and the second one is the law of Hague. The law of Geneva, designed to protect those who are no longer involved in fighting, but also those who not taking part in hostilities or civilians. And the law of the Hague is contain the rights and obligation of belligerents during the conduct of military operation. Although only state can become a party to treaties, the rule of IHL must be respected by all parties to an armed conflict, irrespective of whether they are a state or non-state entity. However, the application to the correct legal framework depends on the type of the armed conflict. There are two main types of conflict. The first one is international and the second one is non-international. The international armed conflict involves fighting between at least two states, and the law that applicable to it is the Geneva Convention. The non-international armed conflict is fighting between two or more armed groups but no state involvement. For example, between February and October 2011, Libya was engaged in an armed conflict. When the Libyan revolution broke out, Libya was in a state of a non-international armed conflict, the fighting between the pro-Gaddafi and the rebel group. Libya was also engaged in international armed conflict with the states participating militarily in the implementation of the measure authorized by UN Security Council resolution in 1973, and this is included the establishment of no-fly zone over Libya. There are three main principles in international humanitarian law. The first one is proportionality, the second one is necessity, and the third one is distinction. The third main principle of IHL is related to the distinction between civilian objects and military objectives. The civilian cannot take part in hostilities, and they have no rights to join the hostilities. If they join, they may be punished. Generally, they are protected as civilian in the hands of the enemy and protected against attacks and effect of the hostilities. For the combatants, they do take part in hostilities. They have right to take part of it and may not be punished if they join the army. They are protected even when they are no longer participate in hostilities. Protected if they have fallen into the power of enemy, if they are wounded or sick, and protected against some means and method of warfare even when they are fighting. That's all for my part. The next part will be continued by my friend.
On this third part, I'm going to explain about humanitarian intervention because it is one of the most controversial things in international law as well as international humanitarian law. So, humanitarian intervention, according to Holzgriff, is a threat or use of force across the state borders by a state or other groups of the state aimed to prevent the violation of human rights or other fundamental things of individuals without the permission of the state within the territory where the force is applied. There are many examples of humanitarian intervention. One of it is in Iraq on 1991 when provision of humanitarian assistance to any Kurds by the US-led coalition troops and maintenance to a no-fly zone to prevent attack by Iraqi airstrikes. Second is in Somalia in 1992. The USA and the UN intervened to ensure the delivery of international humanitarian aid to the region. And the third is in Kosovo in 1999, the NATO bombing of Belgrade as a response to widespread attacks to the civilian population. And there are many other examples of humanitarian interventions. However, there are some doubts or critics about humanitarian intervention. The first is about human rights obligations. When there is a humanitarian intervention, it means that a state is failed to protect its citizens' human rights. The second is about security. When military starts to involve in the state's matter, it increases the risk or potential the individuals to be harmed. And the third is about migrations. Is the consequences, the use of force, and the threat to security attached to it, many people become refugees. There are many other critics regarding these humanitarian interventions, and among those critics come one question: who is the one that is responsible for this action of using of force? Then there is one thing called R2P. R2P said a sovereign state must be able to protect its own citizens and also its human rights. So, when a state cannot fulfill it, other states can come to help to protect the citizens. R2P is a bit different with the traditional idea of humanitarian intervention because R2P are highlighting three things which are to prevent, to react, and to rebuild. It means that when there is a violation, human rights violation in other states, another states can come to help and to protect the people and also to solve that the use of force on other states. So other states are allowed to do so.